Everyone, welcome. Welcome to the third part of the Shady Pink Elephant End of Life series. Tonight we have Stephanie Fajuri, who is the supervising attorney with the Disability Rights Legal Center's Cancer Legal Resource Center, supervising attorney. She provides legal services to people with cancer-related issues, presents educational seminars throughout the nation, oversees the center's telephone assistance line, and serves as the primary supervisor for the Cancer Legal Resource Center staff and volunteers. She was selected as a 2015-2016 Health Team Fellow in the Women's Policy Institute, a leadership and public policy training program sponsored by the Women's Foundation of California. And there's great information included on our Facebook event page for this. I will just add that I've had the pleasure of speaking with her tonight about her being a member of Legal Voices, which is a chorus affiliated with the LA Lawyers Philharmonic. She's going to talk to us tonight about the practical matters of end-of-life planning, and I'm really delighted because I refer people to the Cancer Legal Resource Center all the time, and I'm so grateful for their resource and their expertise. Please know that if you are a study participant or a young woman who is not a study participant on the event tonight, there will be a survey afterwards that we will post at the end of the presentation. If you're a social worker or a nurse who is seeking the 1 free hour of continuing education, which has been approved for this presentation, we'll post information about that at the end. So without further ado, I'm happy to turn it over to Stephanie.
Great, thanks. Thank you so much. So just so you know, the Cancer Legal Resource Center is a program of the Disability Rights Legal Center, and we're based in Los Angeles, California, so I apologize to those of you who are currently suffering through very chilly weather. I hear it's kind of miserable on the East Coast right now, but it's a balmy 85 in Los Angeles. So we are a program that has the mission to provide information and resources on cancer-related legal issues to cancer patients, survivors, caregivers, healthcare professionals, employers, and pretty much anyone else who is coping with cancer. Now, we generally operate on the education model, which means that our program likes to educate people about what their rights are, empower cancer patients to know that they're able to advocate for themselves, hopefully without the assistance of an attorney. Trying to sort of educate myself out of a job here, I guess. And all of our services are available in both English and Spanish, and then we also utilize a language line for our telephone assistance line for people who contact us who speak languages other than English and Spanish. And all of our services are confidential. We also have a lot of educational resources on our website. We provide free webinars generally once a month. We have all of our old webinars, and by old I mean like a couple months because they're all from 2015. Those are all available on our website on a variety of topics. We also have educational handouts and manuals available on our website as well, including a healthcare professionals manual, which we are currently in the process of revising. And we also have a new patient legal handbook, which is also available on our website in both English and Spanish. It provides a really brief overview of a lot of the cancer-related legal issues that our callers face. So please feel free to check out our website for some additional information. And the other thing I wanted to let you all know about is, obviously we're going to leave some time for questions at the end of this presentation, and I really would like to be able to answer everyone's questions if there's time. But if there are questions that come up later, or if there are questions that I might not know the answer to tonight, please do feel free to utilize our National Telephone Assistance Line. This is our free service. It's a hotline. The number is 866-THE-CLRC. So on the screen there, it's 866-843-2572. And we also have an online intake form in case it's easier for you to fill out the intake online, and then we can follow up with you that way. So, that I will try to answer questions tonight to the best of my ability, but that's not the end of the road. You can always follow up with us on our National Telephone Assistance Line as well. So let's dive right in here to go over some of the various parts that go into advanced planning. Advanced planning can be a difficult topic to talk about sometimes, but if you watched the previous 2 parts of this series, or even if you didn't, hopefully you might have garnered a few tips along the way about facing mortality, how to talk about death, and then some of the obviously very important aspects of hospice and palliative care. So what I'm going to talk about today goes along with both of those previous parts to this series, and sort of gives you a little bit more practical information about how to go about actually planning ahead so that you can make sure that your wishes are upheld. Now, just so you know, a study that was published in the January 2014 edition of the American Journal of Preventive Medicine took a look at adults in the US who did and did not have advanced directives. And of the more than 7,900 respondents to the survey, only 26.3% of them had an advanced directive. So obviously you are here participating, learning more. You guys are most likely going to end up, hopefully, making some plans for the future. Unfortunately, there are a lot of people out there who either are unaware of what these tools even are or how to complete them, or if they are, maybe they don't think that they need it yet. So it is important to document your wishes and to plan ahead. Even if you think that everyone who's close to you, your friends and family, knows what you want, both with respect to how your property is handled and with respect to your personal health care decisions, if it's not in writing, that might not be enough. And this is an issue that a lot of people face. So hopefully we will help you avoid that by going into a little bit more detail here. So here's a little bit of a roadmap for this webinar. First, we're going to talk about advanced planning in terms of people and property. We'll talk about the tools you can use to protect your assets, decide who gets what when you die, and that includes property and dependents, in case you have children. And then we'll also talk about designating someone to manage your property and your finances if you become unable to do so. And then second, in part 2, we will talk about advanced planning in terms of your healthcare. So we'll talk about the tools you can use to document any specific wishes you may have concerning the treatment you want or don't want in a medical emergency, and to name someone to make healthcare decisions for you if you become incapacitated. So tools for planning ahead. People and property. We're going to go into a little bit of detail here about wills, living trusts, and durable powers of attorney for financial affairs. And I just want to give you a heads up that the requirements for each of these to make them valid does vary from state to state. So I'm here in Los Angeles in California. I'm going to use a lot of California examples, but just remember that if you live in a state that is not California, Some of the rules might be a little bit different, and you can always follow up with the CLRC afterwards if you have more specific questions about what makes a will valid in Georgia, for example. So moving right along here, the first steps when we're talking about planning ahead for, what you want to happen with your property, the first thing you have to do is think about your estate. And so sometimes you'll hear advanced planning referred to as estate planning. I like to use the term advanced planning because I think estate planning sort of throws some people off. They think about, okay, we're talking about estates. Are we talking about Downton Abbey? No, we're not. Whether or not you own a huge property like Downton Abbey, or if you are renting an apartment that's a studio and have little to no furniture, you still have an estate. So your estate consists of all property or interests in property which you own, no matter how big or how small. The simplest examples are those assets which are in your name alone, such as a bank account, or if you own real estate or stock or bonds, and furniture, furnishings, jewelry. So once you have an idea of what property you own, you can begin to think about who you want to give it to. And one thing I do want to note here, I did put debt on here because it is also part of your estate. So your estate might own things, but you also might be in debt, and there also might be debts owed to you. And so one thing that I want to just really quickly let people know about is if you have student loan debt, you might be able to get it discharged depending on what types of loans you have if you are currently permanently and totally disabled. So one thing that you might want to think about if you are starting to think about, how you want your property divided or how you're managing your finances right now, just as a little side note, if you have student loan debt and you are on disability benefits, and it seems like that's probably what's going to continue through the rest of your life, there is a slight possibility you might be able to get your loans discharged. So if you have additional questions about student loan discharge, you can always contact the CLRC. So, many young people, especially these days, and I guess it sort of depends on where you're living, you might not actually own a ton of property. So, for people like me living in Los Angeles, real estate is crazy expensive. You might not own a lot. So it's possible that really planning ahead for property might not be your #1 priority. But for those of you who do own property or do care about what limited property you do own and where it goes when you pass away, it is important to understand exactly how that property is owned. So remember, you can only give something away that is entirely yours. If you own a share of something, you can only give away your share. So that means there's generally 2 types of ownership. There's sole and joint. So one example might be maybe you and your brother own a car together. Well, if both of your names are on the deed, that probably means that you can't just say, oh, when I pass away, I want my sister to have my car. Well, you can probably give your sister your share of the car, but you can only give away what you completely own yourself. So again, property laws also vary from state to state. So depending on what type of property you are trying to make plans for, whether it's a house or, like I said, a car or anything else, you might want to consult with an attorney to find out which ownership rules apply and how you can handle that. The one very basic tool for advanced planning is a will. A will is a document where you basically lay out who you want your property to go to, but of course there are certain formalities, which again vary from state to state. So there's generally 3 different ways to create a will. There is a prepared will, which is sort of the traditional route where You go to a lawyer, they draft the will for you. It's probably witnessed by two people who are not going to be receiving anything from the will. So that's one option. Another option, depending on your state and what their rules are, they might have something called a statutory will. And a statutory will is essentially a fill-in-the-blank will form that was written into state law. So if you basically print out the statutory will and fill out the will form with, your name and, the specific property that you're trying to give away, in some states that's also considered valid. And it probably also would need to be witnessed and signed by two disinterested witnesses. So disinterested means that they're not receiving anything. So, if you want to give all of your books to your best friend probably can't be one of the people who's witnessing your will. Now, the last option, again, is only available in some states, not all, but it's called a holographic will. And a holographic will has nothing to do with, gem in the holograms or, any of the little hologram kind of stickers, or holograms have nothing to do with it. A holographic will is a will that is entirely written in the person's handwriting who is trying to make plans to give away their property. So again, varies from state to state. Some states do not recognize holographic wills, but some do, and the whole thing just has to be completely in your handwriting. Usually it has to be dated and signed. So there are a few different options that don't necessarily require you to go to a lawyer to have that person draft you a will. But if you're really concerned about making sure that your will complies with your state law, usually I would say it can be a good idea to go and just make sure that an attorney has reviewed it at the very least. And one thing that I want to also flag for you is that when you're thinking about drafting a will or preparing a will, this is also a good time to think about making plans if you have minor children. You can put in your will who you want to have custody of your children or child. But another option for that type of planning for minor children could also be naming a joint guardian now while you're still alive so that the transition is a little bit more seamless. So it's also really a good idea to plan ahead for pets if you do have any pets, dogs, cats, etc. I think a lot of people sort of think, well, I don't really own property, I don't own a house, I don't care about my car, like my books, whatever, but they sort of forget that there needs to be a plan in place for their pets. And it's remarkable how many people forget about that, and then, often those animals end up in shelters. So, it's a very good idea to start thinking if you have children or pets or other property that you are very concerned about where it's going to go and who's going to get it. You should go ahead and think about possibly making a will. So don't forget also to review assets that you may have set up previously with a beneficiary already named. So a beneficiary, that's the person who's going to receive whatever the thing is that needs to be given away. So a common example of something that might not fall under a will where you might have already named a beneficiary is life insurance, IRAs, retirement plans, annuities. Often if you are starting a new job and you're working and you fill out, maybe your employer offers life insurance, you usually have to name a beneficiary right there. So that's not something that would fall under your will. But let's say you've been working at the same place for 5-10 years, maybe the first person that you named, maybe they're no longer in your life, maybe they have passed away themselves. It's a good idea to reassess previous planning so that it reflects what your current wishes are. So even if you already have a will, it's a good idea to go back and look back through that and make sure that it still reflects your current wishes. And again, that's also important to do when there are any major changes in your family, like births or deaths, and also when the value of your assets significantly increase or decrease. And then also if you purchase or sell a piece of real estate. And finally, if you move to a new state, you might also then want to reassess what you've previously done to make sure that it also complies with your new home state's law. So what if you reassess a previous will? You go back and look over a will that you had made a few years ago and you want to make some changes. Well, to be honest, the easiest way to amend a will is probably to create a new will altogether and void the old one. What counts as voiding a will does vary from state to state, but that's information that we can easily find for you at the CLRC, or you can contact your state bar association. In California, for example, the state statute says that a will is revoked if there is a subsequent will which revokes the prior will expressly or by inconsistency. So sometimes if you create a new will altogether, if anything's different, sometimes that will automatically void the previous will. You can also potentially burn, tear, cancel, obliterate. These are words directly from the statute, not my own. Or destroy with the intent for the purpose of revoking it. So, there are a couple different ways to void an old will. If you decide, I really don't want to void the whole thing, most of it's fine, I just want to add this one thing. Okay, you can do that, but don't cross out anything. If the will was typed up and prepared by a lawyer, do not handwrite anything on the will. Usually those things will potentially void the whole thing altogether. So you have to use something called a codicil. A codicil is essentially another document that's added to the end of the will that needs to be verified the same way that you would do with a regular will. So let's say in your state, to make sure that a full will is valid, you have to have 2 disinterested witnesses sign it and date it. If that's what the requirement is for a full will, you would have to have 2 disinterested witnesses sign and date the codicil as well. So just for whatever that's worth, if you want to make some changes, that is possible. Well, what if you don't get around to making a will? Or what if you decide, I really don't care what happens to my property, that's not important to me right now, focusing on other things? Well, there are usually plans in place for how that works out. So if you pass away without a will, that's called dying intestate. State laws usually then determine where your estate will go, and there is a list of heirs that is preset by law that the courts will reference to distribute your belongings, which may not actually result in your property being distributed the way that you wanted. For example, if you die without a spouse or children, your estate might go to your parents, if they're still alive, rather than to any of your siblings. Maybe you would have preferred for your estate to be split among all of them. If you don't have a will, you really don't have any say in what happens. So again, this is true except for life insurance policies, certain joint accounts, joint property. Generally spouses own a house as joint tenants with right of survivorship, which essentially means that if one spouse dies, the other spouse gets the whole thing without having to have that in the will or as a whole separate thing. So again, if you really do care about what's going to happen to your property, it's probably good to plan ahead for that. If you have a will, it will go through probate, which is a public a public forum, so everything becomes public record. It can be costly. There are costs associated with having to probate an estate. So one way to avoid that is to potentially create something called a trust instead. So the most common type of trust is a living trust. And a living trust is a written agreement where you name beneficiaries and include instructions on how you want your property distributed to your beneficiaries upon your death. You're considered the trustor. You're essentially creating a document where you move all of your property that you own into the name of the trust. So if you own a house, your name might have to change on the deed. The deed would say that it is part of the trust as opposed to just part of your property. So if you have a trust, you don't have to go through probate, so that's one benefit. And it is more common for larger or more complicated estates to have a trust, because the process for administering a trust is a lot more seamless than with a will, because, again, you don't have to go through probate. One thing that I do want to flag about the difference between trusts and wills that can be somewhat useful is, as you can imagine, if you can handwrite a will or use a form, it's probably going to be pretty inexpensive to set up a will. But if you have a will and it has to go through probate, there are probate costs associated with it. If you, on the other hand, set up a trust is more complicated to set up. It generally has to be done by an attorney, so you'll have to pay the attorney for his or her time, but then you avoid probate. So you might want to think, if you're trying to figure out which one might be better for you and for your situation, one thing to consider might be, do you care about the upfront costs now? Do you care if there are costs, associated afterwards? Do you care about whether or not, the record of all of your property becomes public? So, those are certain things that you'll have to decide on your own. But if you do decide to go talk to an attorney, one thing to keep in mind, obviously you can always shop around for attorneys. And estate planning attorneys generally do one of two things. So they will usually either charge you on an hourly basis, or sometimes they'll just charge you a flat fee for the whole thing, and then it might be, kind of a lot of money, but they sometimes will say, any changes that you want made in the future, you can just come back. We won't charge you anything more. This is the flat rate for the whole thing. So again, you can shop around. You can try to figure out which makes more sense for you, a trust or a will. And if you really don't own much property and don't really care, then, you can certainly skip all of that. But what if you need help managing your property now? So some people don't, maybe it's not important to them where their property goes later, but maybe, if you have a long hospital stay, or if you are, going through treatment and have a billion other things that are occupying your mind, you might not be able to really manage your financial affairs the way that you would otherwise. So many cancer patients who are facing the end of their lives or who are going through treatment often need assistance in managing their financial affairs well before their end of their lives. So a power of attorney for financial affairs is another document. It's a legally binding document that you prepare or have prepared for you to sign, where you choose a trusted person who's known as your agent or your power of attorney to act for you if you become incapacitated, or if you're just not able to do it all yourself. So whether or not you become incapacitated is usually determined by a doctor or a judge, but there are a couple different types of powers of attorney where some of them only go into effect once you've become incapacitated. That's usually called a springing power of attorney because it springs into action when a certain event takes place. There's also just, a regular power of attorney where, let's say, you're not incapacitated, you're in the hospital, but you don't have access to your checkbook, it was left at home, somebody's got to go physically drop off your rent check to your landlord. That's a situation where it might also make sense to have a power of attorney for financial affairs put in place so that somebody else that you trust can help you manage your affairs, help you pay your rent, pay your bills, write checks for you on your behalf, working, obviously, hopefully, in your best interest. So, a lot of times, a lot of states do have power of attorney forms available as well. So that's another thing that you might want to look for. You don't necessarily have to go and have an attorney draft one of these. There are a lot of free forms available. Depending on your state, it might have to be notarized. Generally does have to be signed and dated. And one other thing that I want to flag about powers of attorney for finances is that usually banks and other, like if you have like a mutual fund or maybe like a 401k or something, usually financial institutions like those will often have their own forms as well. So even if you have a power of attorney for financial affairs, they would still likely have to honor it. But because many of them do also have their own forms, it can just save a lot of hassle and headache, both for you and for your agent, if you also look into that ahead of time and have the proper forms at your bank filled out already. Because then there is really no question, okay, does this person have, can this person really have access to your account? So now that we've talked a little bit about how to plan ahead for your finances and your property and potentially your pets and your children, we're going to switch gears here a little bit and talk about planning ahead for healthcare. So we're going to talk a little bit about the different tools for planning for your medical treatment or lack thereof at the end of your life, or when you're not able to make decisions for yourself. And again, just as a little warning, the requirements for each of these may vary depending on state law. So again, if you have specific questions about what makes one of these documents valid, call the CLRC or contact an attorney in your state, and we can certainly share that information. And one little note that I want to let you guys know about is that Medicare actually has finally just started paying for doctor-patient consultations for end-of-life care just last month. So that's very exciting. So we're going to go into a little bit about advanced healthcare directives, living wills, which is actually usually part of an advanced healthcare directive, powers of attorney for health, again, that's part of an advanced healthcare directive usually. But I know that all of these are terms that a lot of people use interchangeably and might not really know what the difference is. And then I'm also going to talk a bit about physician orders for life-sustaining treatment, and then I'm going to go into a little bit about patients' rights at the end of their lives. So first, advanced healthcare directives. So advanced healthcare directives are written instructions that state your wishes about the medical care and treatment you want to receive if you're unable to make medical decisions for yourself. They are intended to avoid unwanted care, reduce suffering, and ensure that your wishes are honored at the end of your life. Generally, an advanced healthcare directive must be signed and dated in the presence of 2 witnesses, and those 2 witnesses usually cannot be your healthcare provider or an employee of your healthcare provider. So a lot of hospitals have their own forms for advanced healthcare directives, and a lot of times before someone goes in for surgery, they'll encourage that patient to go ahead and sign one of their advanced healthcare directive forms. Often, the hospitals will have a notary on staff so they can just notarize it and they don't have to worry about the witnesses. But just keep in mind, if you are filling out an advanced healthcare directive at the hospital or in your doctor's office, usually the witnesses have to be someone who's not employed by your healthcare provider. And so I'm going to go ahead here and talk about the different parts of advanced healthcare directives, because in every state they usually are made up of anywhere from 1 to 5 different parts, and all together they make up your advanced healthcare directive. So one thing that I want to flag here too is that there are, like I said, there are usually forms available at whichever hospital you're being treated at, but if you prefer to, do it on your own or whatever, there are free forms available online, and the forms that we often refer callers to are through Caring Info, which is caringinfo.org, and they have free forms for people in literally every single state. So they include a lot of instructions on how to fill out the forms, what each of the different parts mean. So I'm going to go through this a little bit here just as an example. So in California, the first part of a power of attorney for healthcare, the first part of an advanced healthcare directive is a power of attorney for healthcare. And so some states recognize a power of attorney for healthcare as its own thing. Others have it as part of the advanced directive. Ultimately, you'll figure that out, or I'll help you figure that out for your own state. But just so you have an idea of what each of these different parts are, the first, power of attorney for healthcare. So this is really important, where you are designating an agent. So in some states it's called an agent, some states it's called a power of attorney for healthcare, some states it's called a patient advocate, and regardless, it's all sort of the same thing. And it names someone, a friend, relative, someone else who you trust, to make medical decisions for you when you're not able. So a power of attorney deals with all medical decisions unless you decide to limit it. You can also give specific instructions about what treatment you want or don't want, or other issues that might concern you, but that would go in a different part of the advanced directive. The power of attorney for healthcare is generally just where you're naming somebody that you trust to make those decisions when you're not able to. Now, sometimes we get questions, what qualities do you want to look for in a person who you're going to name your agent? Well, you probably want to name someone who is obviously trustworthy, but you probably want to name someone who shares your values, someone you've talked to about what your end-of-life wishes are. This should not come as a surprise to someone that you have named them. And one thing that I also want to flag is that you probably don't, well, this might vary depending on the person, but I would say for the most part, most people are not going to want to name one of their parents as their agent. Because as you can imagine, it's often a very difficult situation for people to make some of these decisions on behalf of their loved ones. And I think parents in particular would have a very difficult time sometimes following some of the wishes of their children if they conflict with, whatever their emotional state is, right? They love you, they want you to be around. Maybe you've talked about the fact that you don't want to be on a ventilator, but your mom loves you and wants to keep you around as long as possible. It might be hard for her to make that choice. So you definitely want to name someone who's going to follow through with your wishes, and maybe someone who's not going to be making super emotional decisions, someone who's going to, uphold what your goals had been. Part 2, and again, like I said, this varies from state to state, but Part 2 is usually about giving specific instructions. This is also sometimes called a living will, and you can give specific instructions about treatments that you want or don't want, and So, like I said, some states call it a living will, and they recognize a living will as its own separate legally binding document. Other states don't recognize it as its own thing. It's only part of an advanced healthcare directive. But, you know, this is where you can check certain boxes about what you do and don't want. There's also usually a lot of space where you can write very explicit. You can go into detail about what types of treatments you want or don't want. Maybe you do want CPR, but you don't want a ventilator. That's something you can put in. Maybe you're okay with a feeding tube, but I don't know, but maybe you don't want CPR. So, you know, all of those things are things that you can put in there. It's a good idea to think about it before you fill out the form. You know, take a day or two to really evaluate what your wishes actually are before you go ahead and fill that form out. In California, Part 3 is organ donation, and that's where you can specify whether or not you want to be an organ donor upon your death. You can specify which organs you do or do not want to donate. Usually, you know, you register to become an organ donor through your state's DMV, but if this is part of your advanced healthcare directive, that's also another opportunity to potentially save other lives. And in California, Part 4 is where you name your primary physician. Just in case there's any confusion about your medical treatment, if any information is needed from your medical records while you're being treated. Again, this is optional, so not every state includes this. Sometimes your primary physician changes a lot, so you might not want to put that in. That's fine. But if you do, you can certainly put that in. I'm going to change gears here just a little to a POLST. Some states call it a MOLST, but POLST is a physician order for life-sustaining treatment. When it's a MOLST, it's a medical order for life-sustaining treatment. And so this is another tool for planning ahead for your health. It's similar to an advanced directive because it addresses pain management, resuscitation, feeding, etc. But the POLST is completed with the approval of both the patient and the physician, and it has the force of a physician's medical order, and it remains with patients whenever they receive care. This actually becomes part of your medical record, and it's on a bright pink piece of paper so that it can easily be located. So, you know, you don't have to worry about, oh, well, there's 800 different pieces of white paper in my medical records or in my chart or whatever. Well, the pink is supposed to hopefully make it a little bit easier to find. And this is true for any of these advanced planning tools, but it's always a good idea to let people know that you've created them in the first place. You know, I mentioned that it's not a good idea to surprise someone once you've become incapacitated that, oh, all of a sudden your brother finds out that he's your agent. You know, that's a conversation that you should have before naming the person. But either way, let's say you name one of your friends, it's still a good idea to tell your family or tell, you know, other people close to you that you do have an advanced healthcare directive. Can be a good idea to let them know that there's a POLST, just so, or, you know, tell your doctor that you have an advanced directive, etc., just so that there's no confusion. And in case you're curious about some of the differences between a POLST and advanced directive, an advanced directive is generally for people 18 and older, provides instructions for future treatment, appoints a healthcare representative or an agent, does not guide emergency medical personnel, but it does guide inpatient treatment decisions when made available. On the other hand, a POLST is specifically for people with serious illness at any age. It provides medical orders for current treatment, and it does guide actions by emergency medical personnel when made available and inpatient treatment decisions when made available. So, you know, the major difference is that this is a medical order. It's in there. It's it's right in your medical records, but it is really limited to people who have very serious illness, whereas literally anyone can create an advanced healthcare directive and probably should create an advanced healthcare directive. So, you know, one of the issues that we have seen quite a bit, and it's obviously been in the news quite a bit in the last several years, but you know, the issue of end-of-life treatment and what patients' rights are at the end of their lives is very important. So, why would you want to plan ahead for healthcare? Well, in every state, people who are at the end of their lives have certain rights regarding end-of-life treatment, and planning ahead ensures that your rights will be protected. So some of those rights include the right to palliative care, which is you know, care that focuses on pain abatement rather than on prolonging life. And for more information about that, I'm sure you can check out part 1 of the series as well. But you also have the right to refuse food, including through a feeding tube, food and water. You can absolutely refuse those. You also have the right to refuse medical treatment. You have the right to palliative sedation. So palliative sedation is where the patient is essentially, if you're going through a lot of pain and there's really no real amount of pain medication that is going to help, sometimes people choose the option of palliative sedation, which is where you are basically induced into like a coma-like state so that you are sedated, so that you're no longer really feeling the pain. You have the right to have pain adequately managed, and then of course you have the right to have your wishes upheld. These decisions can be extremely difficult for both the patient and his or her family, especially when the patient and family members do not agree with the course of treatment or lack thereof. This is why it's important to document your wishes in an advance directive or post and make it clear to your agent what your wishes are, so that you know your wishes will be upheld even when you might no longer be able to make decisions for yourself. So last but not least, I do want to touch a little bit on a rather controversial issue. There have just been some changes here in the state of California, but with respect to aid in dying or death with dignity, and language does matter. There is a reason why it is called death with dignity and aid in dying and not physician-assisted suicide. It is not suicide. It is a very different thing. So some states have approved aid in dying, which is essentially where a physician gives a prescription for a mentally competent, terminally ill patient to ingest certain, prescription medication to achieve a peaceful death if the suffering is unbearable. And upwards of 70% of Americans do support this option. So all of the states that do have this as an option do impose significant limitations on eligibility. It's not like anybody who wants it can just automatically, no problem, just call up their doctor and they've got the prescription right the next day, necessarily. So you have to be a resident of that state, you do have to be terminally ill, and you do have to be mentally competent. So usually that means that you have to be evaluated by a psychiatrist, sometimes more than once, depending on what state you're in, etc. And so if you're curious about which states do allow for aid in dying, it's permitted by statute, by state law, in Oregon, Washington, Vermont, and California, although in California the law has not yet gone into effect. In New Mexico, there's currently, the state constitution does provide for the right to aid in dying, but there have been some appeals to that. They're still waiting on a decision from the New Mexico Supreme Court. And there was also a Supreme Court decision in Montana that does also allow for aid in dying. There are some states where it is explicitly prohibited by statute, which includes Arkansas, Idaho, and Georgia. And there's a lot of movement to expand this option in other states. So, for example, the executive director of the Disability Rights Legal Center, which is where I work, she is a real champion for patients' rights in this area, and there is ongoing litigation in New York to try to expand it in New York as well. So, what happens if your loved one, or if you, didn't plan ahead? Unfortunately, fortunately, there is sort of a safety net so that there are options so that if someone's not able to make decisions on their own, whether that's with respect to their current finances or if their current healthcare situation, there is an option called conservatorship, and in some states it's called guardianship. And it's a judicial procedure that appoints someone to take charge of a person's legal, financial, and personal affairs when they are deemed not legally competent. So to create a conservatorship, usually a petition has to be submitted to the court by someone who's asking to be appointed as the conservator. So that can be a spouse, a relative, friend, doesn't matter, as long as it's someone who can show why they would be the right choice to be the conservator of that person. The petition usually has to contain information about why the individual cannot manage his or her financial affairs or make decisions concerning his or her personal care. And then the court will conduct an investigation and hold hearings to determine whether the person actually is incapacitated and whether the appointment of a conservator is required. So as you can imagine, anytime you have to file something in court, that usually costs money. And obviously it's going to cost time for the person to potentially file the petition, go to the hearings. Who knows how long it'll take for the investigation and for that hearing date to even get set. So if you are concerned at all about planning ahead and making sure that your wishes are actually upheld, the easiest way to do that is to do it now by creating an advanced healthcare directive, drafting a will if necessary, so that your loved ones don't have to go this route, which ultimately might not really benefit either of you in the way that you would like. There are a few resources that I wanted to share. Caringinfo.org, again, has lots of free forms for advanced healthcare directives. Compassion and Choices has a lot of information about end-of-life treatment options and end-of-life access. And then, of course, the Cancer Legal Resource Center. So I did save a few minutes for questions. I know it was a lot of information to go through. So I think at this point, I am going to turn it back over to Jean.
Great, thank you so much. We did have a question from one of the participants, and I am going back through. It's a question that says, great info on property and wills, identifying custody agreements for kids and pets, but it seems geared toward a single person. Does a spouse automatically take that place?
Sorry, so does the spouse automatically take the place for the advanced directive?
Yeah, I think that's for wills. For regular wills, I think part of the talk seemed geared toward if you were single. That's one of the things that one of the participants had an impression about. So if you're married, is it an automatic that your spouse would be the first?
Yeah, so it might vary depending on the state, but for the most part, if you are married, generally your property does go to your spouse. There's a difference if you live in a state where there is something called community property, and if you came into the marriage with certain property that might not be part of the community. So it gets a little bit complicated when we're talking about spouses, but for the most part, in most states, yeah, if you are married, your property goes to your spouse, and it might also potentially go to your children if you have children, but for the most part, yeah, it does go to your spouse.
Okay. I had, a lot of times young adults don't have a lot of property. They haven't had the opportunity to build up a 401k or some sort of retirement, and they may not own their home yet. So I just want to reiterate the idea of estate, that if you don't have these concrete things in place, that it's still really important to write down your books, your music, your clothes. I mean, I'm sure you've had conversations like that. Can you speak a little bit more to sort of the work you've done with young adults around those types of conversations?
Sure. Yeah, I mean, for example, I know someone who she has stage 4 breast cancer. She's quite young. I don't know exactly how old. I think maybe around 30. And she has had a long-term boyfriend, and they're not married. But if she passed away without a will, all of her property would likely go to her parents because they're still around, and that's, something that's probably on the horizon. And she still went through the process to have a will made, even though, they don't own property together. They live in an apartment. There's student loan debt, etc. But she wanted to make sure that some of her property would go to her boyfriend, even though by law it wouldn't have gone to him. So I think, yeah, I do think it is important that even, like I said, I live in Los Angeles. It doesn't matter where you live. If you live in an apartment and, all you have is the shirt on your back and, a bed to sleep in, maybe it's important to you who gets that shirt. That's right. Still part of your estate.
That's right. We've had another question from a stage 4 patient who wants to know if a stage 4 patient should have a pulsed or mulched at each medical facility where they receive treatment if you get treatment in multiple states.
Yes. I would say that that's probably a yes, and that's something that the patient should discuss with her doctor at each of the facilities, because the rules might be different, and the whole point is that it's right there in your chart, right there with you. And so if you're at different facilities, they might not have access to the one, at the other facilities.
Okay. You talked about debt forgiveness a little bit earlier, and I'm wondering what paperwork a cancer survivor might need, from there. Is it just a diagnosis letter? Is it a pathology report? What might the person holding the debt need for that action?
So that was specifically about student loans, and it is kind of a complicated process. We actually have a webinar about that on our website, on the Cancer Legal Resource Center website.
Okay.
So if that's something that's applicable to, any of the situations of any of the people who are joining us, I would recommend checking that out because it's kind of a lot to go into. But generally, you need to have proof that you are permanently and totally disabled, and usually that's because you can show that you're on SSDI or SSI, and or some other type of disability insurance, or veterans benefits or something like that, and then or potentially a letter from a doctor certifying that you meet the requirements. But I think for the most part, it's when people have are on SSDI and can show that.
Okay. I really love that you brought up remembering our pets. And I wondered if a sort of an adjunct to adding your pets to your will, do you need to then let your vet know anything?
I think that that couldn't hurt. I would think that in addition to, okay, so let's say you're making plans. I have a cat, and I've, if I want my brother to take my cat because he loves cats and has cats himself, if I wanted him to take my cat, I'd probably also want to let him know which vet I've been going to so that he can get records if necessary. And then you might want to tell the vet, but I mean, that might be less important than just making sure that whoever you are naming to take your pet, or whoever, if you're naming someone in your will to take your children, not that they're the same, I promise I'm not equating children and pets, but you want to have those conversations before you put it in writing so that it doesn't come as a surprise.
We had another question about whether, besides having the advance directive in the hands of the doctor, where else should a copy be kept?
I would say that it probably doesn't hurt to have a bunch of copies. Probably one in wherever you keep your important documents, whether that's a safe deposit box, although I don't know, probably any millennials or young people. I think the only person I know who has a safe deposit box is probably my grandma. But wherever you keep your important documents, and let someone know that it's there, and then you probably want to give a copy to whoever you're naming as your agent. And one thing that I didn't mention, just because there kind of wasn't enough space on the slide, but for naming an agent, there's usually an option to name an alternate agent. Sometimes we get questions from people who say, oh, can I name more than one person? And generally, it's not a good idea to name more than one person to be the agent at the same time, because what if they don't agree? Then what happens? Whose wishes get upheld? Maybe not yours. But it is a good idea to have an alternate agent, especially if you live far away from the person that you really want to make those decisions. For example, in my advance directive, my brother lives in Chicago. I'm here in Los Angeles. I might want to name a local alternate agent so that if there is an emergency, there's someone they can call who can be there at the hospital immediately. Whereas, and then, the next day when my brother's able to get into town or whatever, then he can take over.
Okay. Now another question that says, do you know if all states or funeral homes require a signed waiver if someone desires to be cremated?
That is not a question I've ever been asked.
Please stop the speaker.
I don't want to make up an answer, so that is something that I'm happy to look into.
Yeah. I will just say my mother was cremated, so I don't know that. I think you probably have to have a copy of the will and the death certificate for the funeral home. But that was
I would think
Carolina,
a copy of the death certificate for sure. Yeah.
I think for all of these questions, particularly in thinking about making these plans, ask now. While you are putting it in writing in whatever state you're in. I'm assuming, and Stephanie, correct me if I'm wrong, each state will have some equivalent of a pro bono legal resource, so that if a young adult really can't afford an attorney, they can call the equivalent of, what's the National Legal Association?
Well, so every state has a bar association usually that has some pro bono requirements. Most state bar association websites that I've been on include information specifically about advanced planning or estate planning. It's usually called estate planning. So they might explicitly have information about how to set up a will, how to set up an advance directive. But for people who maybe can't afford to go to a private attorney, another option is usually to go to a legal aid organization. And legal aid often does provide assistance, either low cost or no cost, to do estate planning. And sometimes there are estate planning clinics, like will drafting clinics and stuff like that. And like I said, with a lot of the advanced directive forms, you can usually get those for free at your wherever you're being treated at your hospital, and then certainly online.
Yeah. So it's probably fair to say I'm an oncology social worker by training. I used to work on the provider side. I just want to make sure to say this. All of these are such good resources, and it's probably going to be up to the survivor or a family member to ask for these things. It might seem obvious that someone would offer it, and I wish it were the case, but in my experience, it's more the case that you're going to have to ask for those things, including what I'm so glad to hear about, which is an end-of-life care visit. I feel certain, since that is so new, that regardless of stage, regardless of cancer type, if you're interested in knowing what that is, you have the right to ask for it, and you probably will have to make a certain kind of appointment to do that when you leave for your next visit.
Certainly.
Okay. Is it okay to name an attorney to be your executor or your agent?
Oh, sure. Yeah, absolutely. There's nothing that would preclude that unless that attorney is the one who drafted the will for you. There might be a conflict. But yeah, I mean, if your best friend is an attorney and you trust that that person is going, or even if it's not your best friend, maybe it's some attorney you've used for something else unrelated to drafting your will, you trust that person to be your agent or your executor, by all means, there's no limitation that I'm aware of.
Okay. Let's see. There was a question about, I think you touched on this already, it doesn't make any difference if the person who is the executor on your will is also your healthcare power of attorney. Is that a conflict?
No, it's not. And often, because sometimes we get questions too about people who, or from people who say, well, okay, if I name this agent to make all these decisions for me while I'm alive, or if I've named this person to be my financial power of attorney while I'm alive, well, okay, then what happens once I pass away? If you really trust that person, again, same thing. You can name them to have a whole bunch of responsibility. Just make sure you've talked to them ahead of time.
Okay. And if somebody on the healthcare directive doesn't want to be the agent on all of the parts, is that okay for them to be able to say, I'm only comfortable on certain parts to be the agent?
Yeah, and that's where it can be important to name an alternative agent or a secondary agent, so that if someone decides, you know what, I don't feel equipped to make this decision on her behalf, that's where they can call in that other person to go ahead and do that.
Okay. That's it for our questions. I want to thank you, Stephanie, so much. This has been so helpful and so informative for everyone. And I want to remind everyone that this session is being recorded and will be available probably early next week. So if you know someone who wasn't able to watch that you want to share it with, or if you want to go back and watch it to revisit some of the rich information that was shared tonight, please know that that will be available on the YSC YouTube channel. For those of you who are a study participant in our end-of-life series, we'll be posting, right after I finish talking, a slide that has the link to the post-event survey. If for some reason you're not able to access that, please email me, and my email will be on the last slide. You're welcome to fill out the survey if you're a young survivor participating tonight, but not participating in the study. And if you are a nurse or social worker, please email me. My email will be on the last slide to get the instructions to get your free hour of continuing education. And that concludes tonight's event. Thank you so much for joining us.